But Officer Villarreal was required to make a split-second life and death decision.
What required him to do that? It looked to me as though he was the initiator.
Some cops think the law doesn't apply to them until a judge takes matters into his own hands and takes them to the cleaners.
He had nothing in his hands, and he was shot twice and killed.
In 2016, a pretrial court was formed to decide if Officer Osvaldo Villarreal could claim qualified immunity after fatally shooting Benny Herrera in 2011, setting the stage for a tense legal battle as Herrera's family fought for justice.
This is a tragic case, there's no question about that. But Officer Villarreal was required to make a split-second life and death decision.
What required him to do that? It looked to me as though he was the initiator.
The fact that Mr. Herrera, first of all, he had been acting erratically before the shots were fired. He kept his hand in the front pocket of his hoodie sweatshirt. He moved from a place of relative safety.
But if we're talking about Officer Villarreal, how much did he know about the prior behavior?
He saw all of that. He saw.
I looked at the dash cam from the two vehicles. His is the second vehicle that arrives, correct?
Correct.
So he didn't see all of it.
Well, he said that he saw Mr. Herrera on the shoulder of the roadway because he could see that before Officer Miali's car blocked his view of Mr. Herrera. So he saw him on the shoulder of the roadway. Then he saw him when he moved in front of Officer Miali's car out of a position of relative safety into the roadway. He saw him skipping and running backwards in the street, all the while holding his hand in his pocket.
I have to say what you're saying is inconsistent with what I saw on his own camera. That is to say, the point at which he began to get close enough to see anything. Some of that earlier stuff was on the other camera, but not on his.
Well, I don't recall at what point his camera was turned on, but he testified.
His camera was turned on well before he got to the scene.
The tragedy unfolded when Officer Villarreal arrived at the scene and confronted Herrera, ordering him to remove his hands from his pockets, then firing 2 shots almost instantly.
He testified in deposition that he saw Mr. Herrera on the side of the road, and then he saw.
Well, he can testify to what he wants to testify to, but I want to tell you what I saw on his own camera tells me that the early part of this he did not see, could not see.
I understand your point, Your Honor. He certainly was able to see Mr. Herrera in the street.
Oh, sure.
And he saw him with his hand in his front pocket. He saw him, and he knew he didn't start in the street, so he knew he must have come from somewhere. He was acting strangely. I mean, he was skipping backwards in the street. He was running backwards in the street. And then as the officers moved to box him in, the moment at which he had to make his decision, at the time that he ordered Mr. Herrera to take his hand out of his pocket or to show his hand, his intention was, once the hand was out of the pocket, assuming that Mr. Herrera had calmly stood where he was and moved his hand out of his pocket, his intention was to put Mr. Herrera into a control position.
That was his intention, you say?
That was his intention, and that's in his deposition.
Again, I'm relying on what's on the videotape, and now this is in Officer Villarreal's car. I hear him say, "Take your hand out of your pocket," and I hear the gunshot almost simultaneously.
Exactly.
They cannot be separated by more than a second.
And that's exactly the time period when Officer Villarreal had to make his decision. Before, he was asked in deposition, well, what were you going to do when you asked him to take his hand out of his pocket? Well, I was going to put him in a control position. That's what he intended to do.
Benny Herrera was completely unarmed and posed no danger, yet Officer Villarreal was initially cleared. The twist? Judges who reviewed the body cam footage believed the shooting was serious enough to go to trial.
He's taking his hand out of his pocket.
Yes.
And as he's obeying the officer's command, he gets shot.
But it's the way that he does it, Your Honor. He didn't just stand still and take his hand calmly out of his pocket. As soon as he began to take his hand out of his pocket, he also moved quickly toward the front windshield, the front passenger window of Officer Villarreal's car, and brought his hand up in an arcing motion.
Well, right
he had a fraction of a second to make that
don't
decision.
We have to view this in the light most favorable to the plaintiff here? I mean, and so if we do what you just said right now, offer 2 possibilities. He did it peaceably, or He did it in reaction. So I'm just struggling with, in light of the standard that we have, here, Mr. Herrera was arguably complying with Officer Villarreal's order to remove his hand from his pocket at the time that he was shot. So if that is the case,
A defenseless man was killed without cause. The demand for justice was loud, but the officer's lawyer delivered a defense that was almost as disturbing as the act itself.
Qualified immunity allows for police officers to make mistakes. It allows for the possibility that officers will make mistakes in judgment, and that's exactly what happened here. Officer Villarreal had a choice to make. Do I wait and see whether there's something in the hand that could kill me, or do I shoot? And he made the decision to fire. We know, with the benefit of hindsight, obviously, that that was wrong.
is it significant that Officer, is it Miali?
Miali.
Didn't fire? Chose not to
no,
fire? I mean,
because-
it seems like he had a better vantage point possibly than Mr. Villarreal.
Yeah, Officer Miali was facing, from his point of view, he saw Mr. Herrera's back, not Mr. Herrera's front. So he couldn't see, and he testified in his deposition that he couldn't see Mr. Herrera's hands as they were coming out of his pocket. He also, if he had fired, he would have fired toward an apartment complex. Officer Villarreal fired toward a block wall. Officer Villarreal didn't fire in the direction of anyone other than Mr. Herrera. Mr. Miali would have had to fire potentially in the direction of, in the videos you can see that there are other cars. So there are other people that could have been hit by a bullet from Officer Miali's. Every reasonable police officer faced with exactly the same circumstances that Officer Villarreal faced would have concluded that firing under those circumstances would have been a violation of the Fourth Amendment. The fact that one reasonable officer decided not to shoot, and his circumstances are slightly different, but the fact that one person decided not to shoot doesn't mean that it wasn't objectively reasonable
Counsel,
for Officer Villarreal to shoot.
I guess the issue I'm having here is that these are arguments, in my mind, for a jury. That certainly you can lay these out, but we're at a very limited scope here. This is not jury redo, and
Right.
they're gonna say no, it was he simply had his hand in his pocket, and these officers were coming up on him really strong. They created the tension. They rose the adrenaline, not him. You have to lay out, take their facts, not the facts as you want. You got to stick with their facts and explain why under their facts you win as a matter of law.
I agree, Your Honor.
And right now we're talking about your facts.
As long as
Stick with theirs.
As long as the historic facts are undisputed, the question of whether or not Officer Villarreal's actions were reasonable is a question of law. It's not a question that you give to a jury.
If not for the badge, this act would have been called what it was, a murder. The lawyer's arguments failed to sway the judges, who all seemed ready to strip the officer of his immunity.
At this stage, we have to accept their version of the facts. So you need to explain under their versions of the facts why, as a matter of law, you win.
Under their version of the facts,
Yes.
nobody disputes that Mr. Herrera was acting erratically. No one disputes that he was skipping backwards in the street. That's very strange behavior. Nobody disputes that it was almost simultaneous when Officer Villarreal ordered Mr. Herrera to remove his hand from his pocket, that he started moving toward Officer Villarreal's car, and that
As a matter of law, the shooting here was legal.
yes,
Those three
it
facts.
was objectively reasonable. Well, not just those facts. Officer Villarreal knew that Mr. Herrera was a suspect in a domestic violence incident.
Okay.
He knew that he had gang affiliation, that he was on parole, that he had a warrant out for his arrest. All of those things factor into
On
what
parole,
the officer
I don't
knew.
remember, on parole, they said.
On parole, yes, and there was a warrant out for his arrest.
What do we know about what Officer Villarreal knew with respect to whether he was armed?
This case might be different, but they were told he's not known to be armed. His behavior certainly gave them reason to suspect that he might be armed.
But doesn't our opinion at Espinoza clearly favor, or somewhat favor, denial of qualified immunity under these circumstances? Had refused to put up his hands, had threatened the officers, and an officer believed that she saw something in the suspect's hand, saw him move his arm, and was worried he was going to shoot her. yet we affirmed the denial of qualified immunity in part because the suspect had not brandished a weapon or spoken of a weapon.
The judges pressed with the right questions, and the attorney's defense quickly fell apart. Shockingly, she tried to frame the shooting as a reasonable mistake, but the judge wasn't buying it and was about to make her look foolish in court.
Was that there was a dispute about the historic evidence. Some of the officers argued or said that one of the things that they believed gave them exigent circumstances to go into the house and go into the attic was the fact that they saw a bloody shirt. And some of the officers said it looked like fresh blood. Other officers said it looked like dried blood. And so whether or not there were exigent circumstances,
But here, the domestic violence incident was over.
Yes.
So, I mean, how does that strengthen your case? I mean, that was, if you're arguing that it was an ongoing domestic violence, so.
It wasn't an ongoing domestic violence incident, but they were investigating. He was a suspect in a domestic violence incident in which it was reported that he hit somebody on the head. That was the purpose for stopping him. And at the time, they knew that he was on parole, that there was a warrant out for his arrest, that he had known gang affiliations. And all of those things factor into, am I afraid of this encounter, or do I think that this is going to be a perfectly safe encounter? And heightened the situation to a point where it was objectively reasonable for the officers. Nobody disputes that, for example, that it wasn't objectively reasonable for the officers to have their guns out. They were going to do a felony stop. Domestic violence under California law is a felony. Well, in the split second that decision had to be made, you couldn't put the gun down and pick up a baton. You couldn't put the gun down and pick up a taser, assuming that Officer Villarreal even had a taser. I think there's testimony in the record that he didn't have a taser available to him. He had to make a decision based solely on what he knew at the time. And it's easy for us to sit in hindsight and say, well, Mr. Herrera didn't have a gun. Mr. Herrera didn't really pose any
I don't think
threat.
anyone here said that one time.
No.
Next, the spotlight shifted. The judges called on the plaintiff's attorney to argue why the officer's qualified immunity needs to be removed.
The standard of review on qualified immunity, again, it allows for reasonable mistakes. And as long as the mistake was objectively reasonable, then Officer Villarreal is entitled to qualified immunity. I'd like to reserve the balance of my time.
Let's hear from the other side, and you will have some time.
Thank you.
Good afternoon, everyone. My name is Dale Gallipo, and I'm representing or speaking on behalf of the appellees and the plaintiffs in the underlying case. A host of undisputed facts that we actually think favor the finding of the district court judge. And there's other facts that I think are either disputed or they're entitled to different reasonable inferences. And as I think was pointed out, for this limited purpose of today's hearing, one has to take all the plaintiff's facts as true and all reasonable inferences in their favor.
Well, let's look at what's undisputed, because I think it's a really interesting question we have here. And I think you could say suspiciously kept his hand in his pocket, and that the officers perceived a heavy object in that pocket. That's...
First part, yes. Second part, a little less clear. But I think there's no question that he had his hand in his pocket.
Well, and both officers said it looked like he had something heavy in his pocket. Mr. Herrera rapidly removed his hand and moved quickly, it seemed like, toward the officer's car. Why isn't that enough?
Well, because sticking on the undisputed facts, the officers had no information that any weapon was involved in a crime. They were specifically told he was not known to carry weapons. He took one reasonable inference again is he took his hand out of his pocket in compliance with the command of the officer. When he took his hand out of his pocket, he had nothing in his hand. Another reasonable inference is that the officer could see that he had nothing in his hand before he fired his shots.
And what do you say in response to opposing counsels that he's entitled to make a reasonable mistake?
Every response from the attorney hit its mark, dismantling the officer's narrative beyond repair.
Officers entitled to a reasonable mistake, and that's the end of the analysis. I think for purposes here, one has to look at the facts supporting the plaintiff's version and then decide whether one can say as a matter of law that the shooting is justified. Under our version, both hands were visible and he had nothing in his hands and he was shot twice and killed. That deadly force is a last resort, only to be used in the direst of circumstances, only when no other reasonable measures are available, and that a warning that deadly force is going to be used should be given when practical. Officer Maili, based on his training, said, I was watching very carefully, and unless I saw a gun come out of his pocket and point in our direction, I was not going to shoot. I saw his hand come out of his pocket. I saw nothing in his hand. I did not shoot. One could say he was complying with the command of the officer. He took his hand out. He had nothing in his hand. Both hands are now visible with nothing in them. We believe that's a don't shoot scenario. And even if one could argue, as counsel did, well, this is happening quickly, officers are in a position to make difficult decisions, we believe that's a more appropriate argument for a jury. It's not an argument that lets them prevail as a matter of law. And we believe the district court got this right when she really carefully looked at this and decided this is really a jury question. It was also noted that he didn't take his hand out of his pocket and simulate a gun or point it at someone as if he had a gun. And so, I made a list of some of the undisputed facts.
And that would have made a difference if he had.
Maybe. Now, if it looked like he had a gun, in other words, if the officer would have testified, if the evidence was clear that he pulled an object out of his pocket that everyone thought was a gun and it looked to be pointed at the officer, maybe it's different. No. Did you ever see anything that looked like a gun at any time? No. So we believe that's what makes this case different. And I think if this case hopefully is sent to trial, both sides have good arguments to make to a jury, but we think a jury has to decide these disputed facts.
The defense attorney begged the judges once more to protect Villarreal's immunity, but at this point, it was obvious that the corrupt cop was running out of lifelines.
The jury does not get to decide qualified immunity?
Qualified immunity is a question of law for the court.
You mean, so depending on, the jury has to decide whether or not there's been a constitutional violation, and at trial the jury cannot say to your officer, you're off the hook because you have qualified immunity? That can't be right. But I've never understood it to be outside the province of the jury when it goes to trial, to say that the officer does not have qualified immunity.
The jury has to decide the underlying predicate facts.
I understand that, but I think I'm arguing on your point, if we send this back, I don't think you want to say qualified immunity is no longer available to you at trial.
Absolutely not.
Well, I think that's what you just said. That's why I'm speaking up.
That was not my intention at all.
Before wrapping up, the judges made sure to humiliate the defense attorney one last time, ending the hearing with a knockout punch.
We may not be able to make that determination as a matter of law, but you, when it goes back to trial, if that's the result here, can certainly argue to the jury why Officer Villarreal should not be held responsible and set forth that he should be immune from this.
I agree with
based on all the facts that are presented.
I agree with Your Honor that if this court finds that there is a disputed material fact relevant to the application of qualified immunity, then the case has to go back. The district court's decision has to be affirmed.
If everything goes bad for your client, that is to say, if we send it back, if the jury says no qualified immunity, and if the jury comes in with an award of some amount of damages, will your client pay those damages out of his own pocket, or will it be paid by his employer?
It should be 99.9% of the times it's paid by the employer. I don't see why it would be different.
Well, by statute, California statute says it's paid by the employer unless they're punitives.
Yes,
isn't that right?
That was what I was going to say.
So that doesn't say 99%, it says 100.
Well, I was going to say, unless there were
punitives.
If there were punitive damages, the city would have the option of deciding whether to pay those punitives. My understanding is that
At that point, I got the answer.
The judges wasted no time, issuing a statement that abolished Villarreal's immunity and demanded a trial, citing unlawful deadly force. In the end, the city paid Herrera's family $1.4 million, and the officer lost his badge for good. Well, that brings us to the end of this video. Today, we witnessed how a corrupt cop's lies and arrogance completely unraveled before the judges, leaving him humiliated in the very place he thought he held power. No one is above the law, not even those who wear the badge. Cases like this prove that accountability is essential. Thanks for watching. Please support the channel by subscribing, leaving a like, and comment if you want more like this.
I have PTSD, I have anxiety disorder, depression disorder, 5 years
Don't
old.
put your hands behind your back for me.
No.
Stop resisting.
And I'll be calling the cops on you. And the kids are not yours. You cannot be taking them with. I've not done anything